Paragraph 23, default. There's an A and a B here. If the seller defaults, if the buyer defaults. Basically the same underneath it, those. They're deliver default to the other party and terminate the contracts. In reality, it's probably not quite that simple. You can pursue whatever remedies are available to you. And if the seller defaults and the buyer wins, then the seller's going to pay the buyer's closing costs and vice versa. Now, the buyer has an additional remedy the seller doesn't have, and that's called specific performance. All property is different, unique by definition. Example, I have a $20 bill that's not counterfeit, and I have another $20 bill that's not counterfeit. I really don't care which of those $20 bills I have. Land is not that way. It's unique. Two lots can be right beside each other, same size, same number of trees, same view. They're different. So if the buyer puts in a contract to buy the seller's property and the seller breaches or somehow says, I'm not selling, the buyer can go to court and say, Judge, order the seller to sell me this piece of property because it's totally different than any other pieces of property I have. This paragraph has an interesting thing at the very end of it. It says that the parties may agree to allow a cure period. Most of this contract is under what we call time is of the essence. If you're late, it's over. This allows the parties to come together and say, you know, you really were supposed to do that. I'm going to give you another 48 hours to perform. The other provision here, if the party knows, and in practicality, though I said it doesn't always work out this way, is I, as a seller, may be sure that the buyer's defaulted, and the buyer may be sure that the seller has defaulted. But if one or the other parties knows they defaulted, then the provision under C says that the parties will sign an escrow deposit disbursement agreement or a release agreement, and there are two different forms for that. One can say, okay, we know the deal's not going forward. I'm going to release the earnest money. Seller, I will give you the earnest money because I'm not going to close. I, the buyer, I'm not going to close. I'm going to release the earnest money. The other could be is that we're going to release the earnest money, but you're also releasing the contract. You're not going to sue on the contract. So both of those are there, but there's two different types of releases for you to choose from.